Although everyone is acquainted with the rules and regulations, but I'll just give a short brief. Kindly abide by the time you have provided to the organizing company. Thank you. Judges will be joining soon. Sure. Thank you. Judges, shall we start?
Yes.
Yes, please.
I request the appellant to please begin with it.
Thank you. Greetings of the day. The council seeks permission to present the submission. If the council may repeat, the council seeks permission to present the submission.
Yes, you can.
Yes, you may proceed.
Much obliged. The council seeks permission to address the bench as Your Honours.
Granted.
Much obliged, Your Honours. Your Honours, with the zeal for justice in our heart, this is the council appearing in the Honourable Supreme Court on behalf of the appellant Futis Biotech in the case of Futis Biotech versus Verum Institute. Your Honours, in the first place, the council would like to thank the Honourable Court of Vidya for giving us an opportunity and securing justice for all, even in the unprecedented times of COVID-19. Your Honours, the council has approached the Honourable Court under Article 133, Clause 1 of the Constitution of Vidya 1950. If Your Honours are satisfied with the jurisdiction, the council seeks permission to proceed.
So, how you are entitled under the jurisdiction? Can you explain how you have got this right to come under?
Much obliged, Your Honor. With reference to Article 133 that states the appellate jurisdiction of the Supreme Court in appeals from high courts in regards to civil matters. Your Honors, herein the suit regarding the trademark infringement being a civil matter, the Council has humbly submitted to the Honorable Court under Article 133, as is also referred in the factual matrix in the last paragraph, that the appeal and that the Futis Biotech, the appellant, has approached the Honorable Supreme Court via the appeal. If Your Honors are satisfied, the Council seeks permission to proceed.
Council, to proceed under 133, certification from the High Court is required. So do you have a certification from the High Court?
Much obliged, Your Honors. Your Honors, if Your Honors may be kind enough to refer to the factual matrix.
Yes.
Wherein, indeed, Your Honors. Your Honors, in the last paragraph, it's been clearly stated that aggrieved by the order of the High Court, the Futis Biotech appealed before the Honorable Supreme Court, and now the matter is sub judice before the Honorable Apex Court, and the arguments and issues need to be framed. Thereby, it means that the matter is sub judice before the Honorable Apex Court, and the matter might have already been admitted by the Honorable Supreme Court in regards to the same. And for that particular matter, the High Court, the certificate, as is the requirement to be issued by the High Court, Your Honors, it is actually presumed in such cases to have been granted by the Honorable Supreme Court, as it's clearly stated that the matter is sub judice before the Honorable Apex Court.
But there was no prior hearing. This is the first and final hearing. So
Indeed, Your Honors.
the arguments regarding admission of the present suit has to be done here only.
Indeed, Your
I
Honors.
have to prove
Your
the
Honors.
maintainability of the suit.
Much obliged, Your Honors. Your Honors, apart from referring to the previous contention that the Council has just stated, the Council also humbly submits that in the whole laws and statutes that the Council would have referred, therein this is the provision Article 133, which deals specifically with the civil matters. And if Your Honors are indirectly referring to Article 136, that is the special leave to appeal, via which the Council could have approached the Honorable Court, the Council humbly submits that as was held in the case law of 2010, Jobby versus George and others, this Honorable Supreme Court stated that this provision, Article 136, can only be used as a last resort when all the other remedies have been exhausted. And in the present case, Your Honors, Article 133 as clearly provides for the specific remedy of a civil matter if the Honorable High Court of any state in Vidya has passed the order. Your Honors, it states that the appeal has to be maintained for the civil matters under Article 133.
So you have approached the court under which provision? Clause 1 or 2?
Much obliged, Your Honors. The Council has approached under Clause 1.
Clause 1.
Indeed, Your
So
Honors.
can you explain how the matter is a substantial question of law which involves of a general importance?
Much obliged, Your Honors. Your Honors, the substantial question of law in the present case is that whether the right of trademark infringement can be given superiority apart from the prior user or the passing of rights being existing in the present case or not. Since it's been a long controversial issue, and it'll be great if the Honorable Supreme Court, being in authority, can decide the matter at hand. If Your Honors are satisfied, the Council seeks permission to proceed.
What question?
Much obliged, Your Honors.
Panel judges.
Apologies, Your Honors. If Your Honors could
No,
repeat.
you can proceed.
Much obliged, Your Honors. Your Honors, the Council and the learned co-counsel will take 22.5 minutes of the court's precious time individually to deal with the issues and will reserve 2 minutes for rebuttal. If Your Honors are well versed with the facts of the case, the Council seeks permission to shed some light upon the issues at hand. Your Honors, may the Council...
you can briefly discuss the facts.
Much obliged, Your Honors. Your Honors,
Keep
to
it short.
briefly... Indeed, Your Honors. Your Honors, to briefly enlighten in regards to the facts of the case, in the last 2 years, a global pandemic caused by the virus COVID-19, many people lost their lives and many pharmaceutical companies began working on the vaccines and have developed the same in light of the guidelines being issued by the governments as well of the particular countries. And similarly, the government of Vidya, the Union of Vidya, hereinafter referred as Vidya, supported and urged pharma companies to undertake research on priority and come up with viable solutions. So various pharmaceutical companies came with the solutions. Your Honor, the issue at hand is regarding the fight for Veramgard, that's the trademark. Your Honor, there is one Futis Biotech, the appellants, a sole proprietorship which began its operations in 2011 in the pharmaceutical industry. And another party, the respondent, Verum Institute, is a manufacturer of vaccines which began its operations in 1969. Your Honors, Futis Biotech filed an application for a trademark, Veramgard, in 2016, which was granted to it on 1st January 2018 under Class 5. And on the other hand, the Verum Institute filed for registration of the exactly same trademark, Veramgard, on 1st July 2020 for a drug which has been sold under the same name since 2015 by them. Your Honors, the drug of Verum Institute is mildly effective on symptoms of COVID-19, and the filing comes into effect years after registration of the trademark which has been granted to the appellant. Furthermore, Futis Biotech filed an objection to the trademark being given to the Verum Institute in the Office of Controller General of Patents, Designs and Trademarks, and the matter is sub judice over there. Furthermore, Futis Biotech further filed a suit against Verum Institute in the Commercial Court of Jaipur District, and it was held that Verum Institute was infringing the trademark of Futis Biotech and that it should also pay compensation for the same. In response, Verum Institute appealed the decision in the High Court, and the court held a verdict in their favor. And right now, Your Honors, the appeal has been filed again by the appellant, that is the Futis Biotech, which is sub judice in the Honorable Supreme Court of Vidya. If Your Honors are satisfied, the Council would like to deal with the first issue.
Yes.
Yes, please.
Much obliged, Your Honors. Your Honors, the first issue is that whether there has been trademark infringement by the respondent or not. And before commencing with the same, the Council would like to state that the Learned Co-Counsel will be dealing with the second and the third issues. The second issue is that whether the appellant, Futis Biotech, is a user of the trademark and has the right to use the trademark or not. Thirdly, whether the respondents be ordered an injunction and be asked to pay damages or not. Hereby, to commence with the first issue, Your Honors, the Council submits that there is a direct trademark infringement because of the following three sub-contentions. First is that the appellant has the exclusive right over the trademark Veramgard. If Your Honors may be kind enough to refer to the first line of page 3 of the factual matrix. Are we on the same page, Your Honors?
Yes, we are.
Much obliged, Your Honors. Your Honors, it's vividly mentioned over there that the appellant attained the registration of the trademark Veramgard under its title on 1st January 2018. Now, if Your Honors may refer to Section 28 of the Trademarks Act 1999, the section clearly provides that A, if a proprietor, herein being the Futis Biotech, B, obtains registration for a trademark, that is Veramgard, C, then it gets the exclusive right to use that trademark and to obtain relief in respect of its infringement. Having talked about the right of the appellant, the Council would proceed with the liability of the respondent in the second point of the first subcontention. Your Honors, since the Council has endeavored to establish that the Section 28 provides the exclusive right to the appellant to sue for any trademark infringement occurring, in addition to that, there's Section 29, which provides for the trademark infringements and its essentials. If Your Honors may be kind enough to refer to paragraph 2 of page 3 of the factual matrix, wherein certain facts have been subtly mentioned, and for the court's convenience, the Council would like to portray the chain of events. Your Honors, in March 2016, the appellant came up with a new trademark, Varumgard, and applied for its registration under trademark class 5. On 1st January 2018, the appellant was granted the registration for Varumgard under class 5. And on 1st July 2020, the respondent, the Verum Institute, started using the same trademark for which the appellant got the registration already under its title and applied for registration, under which they had been selling the drug since 2015. Your Honours, therefore, it becomes crystal clear that the respondent used Varumgard despite of the fact that the appellant had got the registration in 2018. Hence, it establishes the direct infringement. Having done the factual analysis, the Council would like to draw Your Honour's attention towards Section 29 of the Act. Your Honours, the Council would state the essentials of Section 29 in 4 points, which, if fulfilled, palpably amounts to infringement of the exclusive rights of the appellant. First is that the mark used by the respondent should be identical to the registered mark. Herein is not merely identical but exactly the same, that is Varumgard. Secondly, that the mark has been affixed on the products and put into sale or use by the respondent. Herein, the factual matrix clearly points out that the respondent has been using the trademark Varumgard on their drug. Thirdly, the mark is likely to cause confusion on the part of the public. Herein, the registration of Varumgard is with the appellant, but it's put into use by the respondent. Thus, it will definitely create confusion among the masses. And Section 29, subsection 3 provides that the court shall presume that it is likely to cause confusion in such cases. Fourthly, that the respondent had not attained any license from the owner of the registered trademark to use it, as is the condition under Section 29, subsection 7. Your Honours, herein the Verum Institute never considered to take any license before using the trademark Varumgard on its products from the appellant. Thus, in light of the above points, the respondent should be held liable for direct infringement of the registered trademark of the appellant under the Trademarks Act, which derives its validity from Part 13 of the Grundnorm of Vidya, Your Honours. That's the Constitution of Vidya, 1950. Which provides that there shall be freedom of trade, commerce, and intercourse in Vidya. If Your Honours are satisfied with the first subcontention, the Council seeks permission to proceed with the second subcontention.
Yes, you may proceed.
Much obliged, Your Honours. Your Honours, the Council humbly submits that there is deceptive similarity by the use of Varumgard by the respondent. Your Honours, under Section 2, Clause H of the Act, deceptively similar mark has been defined as a mark which is deemed to be deceptively similar to another if it is so merely resembles that other mark as to be likely to or cause confusion. In the present case, Your Honours, the mark is not only likely to cause confusion, but definitely, because the mark has been exactly same utilized by the respondents, being Varumgard. As was, if the Council may place reliance upon the landmark judgment of Cadila Healthcare versus Cadila Pharmaceutical Limited 2018, Your Honours, the court observed that because of the diversified population of the country, herein being the same case in regards to Vidya, and varying infrastructure of the medical profession and negligence, it is important that confusion of marks should be strictly prevented in pharmaceuticals and drugs. The court thereby held that in case of medical products, the names of the brand being phonetically similar shall amount to being deceptively similar. Herein, since the mark is not only phonetically similar but exactly the same, consequently, the registration application shall be outrightly rejected. Furthermore, Your Honours, it's been held in Sun Pharma Laboratories Limited versus BDR Pharmaceutical International Private Limited that even dissimilar medical products within the same class could not exist if they create a sense of confusion. Therefore, herein the products under the same class, that is class 5, cannot exist under the same trademark Guard, as it can create confusion among the masses. And since the appellant has already attained the registration of the mark Guard, the respondent should be, the Honorable Court may pass an injunction against the respondents to use the same in any of their products, especially in relation to Class 5. The plea of the respondent, Your Honors, that the drug being sold is a vaccine for COVID-19 virus should not be sustainable in light of the para 2, page 2 of the factual matrix, wherein it's been stated that A, their drug is only somewhat effective on mild symptoms of COVID-19, and B, that the reputed pharmaceutical companies have developed the medicine exactly in the model of a vaccine and have cleared the 3-stage clinical trials that the government has permitted them to undergo. Thus, the respondent's medicine is not in any dire need to be registered for Salus Populi Suprema Lex as well, that is, the welfare of the people is supreme. Herein, the welfare of the people will be more if the likelihood of confusion is avoided in the present case, and the registration which the appellant has already been granted is upheld, and the respondents are being asked to not to continue the use of Guard upon their products, since it will amount to trademark infringement. If Your Honors are satisfied, the Council seeks permission to proceed with the third subcontention.
Yes, proceed.
Much obliged, Your Honors. Your Honors, the Council humbly submits that there is use of arbitrary mark and no wrong has been done on behalf of the appellant. In arguendo, the Council humbly submits that if the Council could establish that Guard is a distinctive or an arbitrary mark, then it could be upheld that the registration which was granted to them is aptly correct. Your Honors, arbitrary mark is a mark which is unique because Guard herein has been derived from two words. One is verum, the Latin term which means truly, reality, or fact, and second is guard, which is derived from the English term as per Merriam-Webster. It means to defend, protect, or shield. Thus, the appellants humbly submit that Guard is an arbitrary mark of the appellant, and since Section 29, subsection 9 clearly postulates that where the distinctive elements of a registered trademark consist of or include words, the trademark may be infringed, as in the present case by the respondents, by their visual representation. Thus, there has been trademark infringement in the present case. Furthermore, to substantiate the third subcontention, the Council humbly submits that in A.R. Khalil and Sons versus Registrar of Trademarks in India, it was held that a combined word which is not found in the English dictionary amounts to an invented word for the purpose of the Act. Therefore, the Council humbly submits that the Guard term is an arbitrary mark of the Foetus Batic in the present case being the appellant. Lastly, Your Honors, it is humbly submitted that one has to not only be aware of their rights, but also be vigilant enough to use it to their advantage. Herein, the Council is actually referring to vigilantibus non dormantibus, which is a legal maxim, which means that the party cannot sleep over his or her rights. Herein, Your Honors, the respondent could have A, raised objections to the registration of the trademark Guard to the registry when the appellant had filed for registration in March 2016. Since there were no objections and since the registry clearly registered it, therefore it establishes the fact that the appellant had gone for due diligence and the respondent should not come for registration of the trademark Guard when it's been already registered under the title of the appellants on 1st January 2018. Furthermore, Your Honors, to substantiate it, the respondent could have also filed post-grant opposition, or they could have filed revocation application if they were so vigilant and cautious towards getting the registration for their products. But however, they did not even file for any revocation application, post-grant opposition, or opposition when they had so many opportunities. The Council humbly submits and relies upon the maxim vigilantibus non dormantibus, and they should not be granted the same even now because the appellant has been aptly granted the registration of the trademark Guard on 1st January 2018. Consequently, the use of Varumgard by the respondent infringes the exclusive rights of the appellant under the Trademarks Act, A. under Section 28 of the Trademarks Act, B. under Section 29 of the Trademarks Act, C. as the Council has relied upon various landmark judgments of the Honorable Supreme Court, including that of Cadila versus Cadila Pharmaceutical Limited, and the Latin maxims as well. Your Honor, thus the Council prays before the Honorable Court to go with the Salus Populi Suprema Lex, that is, the welfare of the people should be the supreme law. Hereby, if Your Honour permits, the Council would request the learned co-counsel to deal with the second and the third issue if Your Honours are completely satisfied with the first contention at hand.
Counsel, as you stated that Viramgad constitute a unique term. So I would like to ask whether you can get the registration. If you take the name just guard, can you get the registration?
Your Honours, as far as the Council is aware, the registration for the term guard can be taken until and unless it becomes a descriptive element in the trademarks.
So just by joining Viram is the name associated with the respondents, right? So are you not encashing upon the prestige or the reputation of the respondents?
Much obliged, Your Honours. Your Honours, the Council humbly submits that when the appellant filed for the registration of the trademark in March 2016, the appellant definitely went through the processes of the trademark, because the evident is that the registry granted the registration. And in the process, there is one concept of due diligence that the appellant would have to go through. And when the appellant did the trademark search, thereby in the trademark search there was no registered concept of Varum or the Varum guard, Your Honours. Had there been anything on the part of the respondents regarding Varum or Varum guard in the registry office, or the registry office could have found the same, Your Honours, thereby there itself it could have been rejected. However, since it's clearly mentioned in the factual matrix in the first line of page 3 that the appellant was granted the registration of the term Varum guard and the trademark was in their favor.
Okay, proceed.
Much obliged, Your Honours. It was an honor to plead first contention before the
Council.
Please, Your Honours.
Yes. So there is a doctrine called doctrine of prior use. So
Indeed, Your Honour.
do you justify your registration of trademark applying Section 34 of the Trademarks Act and the doctrine of prior use? So the respondent were using this Varum term Varum. Already they were in use of this term. They had a medicine which is ongoing. It is well known in the society as well. So how do you justify this concept of prior use, and why should we not favor the respondent on the basis of the prior use?
Much obliged, Your Honours. The Council humbly submits that, first of all, the Council would like to clarify that this particular question will be dealt comprehensively by the learned co-counsel. However, to precisely answer Your Honour's question, the Council submits that for the prior user, the respondents have to establish that there was prior user by the Varum Institute in the first place, because there are essentials of prior user as was laid down in PEPS Industrial Private Limited versus Kurlan Limited 2018. And in the present case, Your Honours, the essentials have not been met because there was no continuous and consistent use of the drug, as is mentioned in the factual matrix. And secondly,
can you refer this factual matrix where it has been provided that it is not in continuous use? And to add on to that, though you have secured a in the year 2016, but till date you have not produced any vaccine or any medicine for the under this trademark, and you are still researching on or you're working on it. It has not been come into market yet. So just you have taken the trademark for the purpose of just to annoy the respondent, or there is something you are doing actually?
Much obliged, Your Honor. The council would like to answer Your Honor's question in two parts. First is that the council placed reliance upon Section 47, which clearly provides that a registered trademark, the registered trademark and the owner of the registered trademark has the right to use the trademark within 5 years. And presently, the 5 years time has not elapsed, and the Futus Biotech still have the time to use it. And furthermore, to substantiate it, the learned co-counsel will be dealing with the definition of use in a wider sense, as has been mentioned, as unlike has been mentioned in the factual matrix. And secondly, Your Honors, the council humbly submits that the use will be actually be dealt by the learned counsel, if Your Honors may allow.
You missed the first question. You mentioned that it is
Please.
mentioned in the factual matrix that the verum guard was not used by the respondents frequently. It was not in use generally. So can you
Much
refer
obliged. Your Honors,
para
the
or
council.
which has been mentioned in the factual matrix?
Please, Your Honor. The council humbly submits that it's not been directly mentioned in the factual matrix. However, if
So you are
Your Honors may
inferring
be
it?
kind, if Your Honors may be kind enough to refer to paragraph page number 3 of the factual matrix.
Yes. Which
The first
paragraph?
line states in the second paragraph.
Yes.
And the council like to substantiate the fact that read the paragraph and the lines that are crucial in the particular aspect for the court's convenience. Herein, it stated that the Verum Institute already had a drug in market since 2015, which was used for cold-like symptoms and anti-allergy related problems. Coming to the date, Your Honors, on 1st July 2020, they applied for trademark registration on 1st July 2020 and started using the name on their drugs, which are being sold under the same name without trademark since 2015. Your Honors, the council humbly submits that nowhere in the factual matrix has it been mentioned that they were consistently using, although it stated that they were using there was a drug in market since 2015. However, it does not substantiate the fact that it was in consistent use. And even if it can be established by the respondent somehow, the council submits that the second essential of volume of sales also need to be established for claiming prior user in the first place. And even if they claim prior user, Your Honors, the council submits that they could not have claimed passing off because of the reason and the fact that there is a trinity test for passing off, and the third essential of trinity test is damages. And in the present case, the Futus Biotech could not be held liable for any damages being caused to the Verum Institute, Your Honors, because the registration actually had been taken by the Futus Biotech, the appellants, Your Honors. And
is it the legal damages you're talking about, or the monetary damages? It has to be an infringement of a legal right. I believe that there is an infringement of legal right if we call about passing off, because they were using the term prior to your registration, and they are actually using the it is in the market, though. Yes, the facts are silent about the sale volume, but the other two remains in the favor of the respondents. And when you're presuming something on your end, we may presume also in their end as well.
Much obliged, Your Honors. The council humbly submits that in regards to damages, it has to be shown that there was some monetary or legal damage being caused to the Verum Institute. However, in the present case, there was no damage being caused to the Verum Institute, to the respondents. And Your Honors, the council would humbly submit that if they were the prior user, in case they were the prior user, the council states, then they should have been vigilant enough to claim for their rights. Within 1 year, when the Futus Biotech went for registration in March 2016, they had a valid right to file for the opposition, which they did not go for. Even after having the registered, even after when the mark was registered in the favor of the Futus Biotech, they could have filed for post-grant opposition. They did not even go for that. Even after the registration was done and the trademark Verum Guard was granted to the Futus Biotech, the respondent could have still filed for a revocation application if they had confidence that they were the prior user. But they again did not go for that as well. Rather, Without conducting due diligence, they filed for registration of the trademark. Had they done due diligence before filing for registration on 1st July 2020, they could have got it right there in front of them that in 2018 the trademark Veramgard was aptly granted to the Futis biotech. It shows malified intention on the part of the respondent that if they would have been vigilant enough, they could have claimed their right at least at one point of time when they had a lot of opportunities to go for, Your Honors. If Your Honors are satisfied, the Council would seek permission for the learned co-counsel to elaborate upon the question of Your Honors in regards to the use, since the learned co-counsel will be dealing with the aspect of use and prior user in detail.
Okay.
Much obliged, Your Honors. It was an honor to submit the first issue at hand.
Your Honor, the Council on behalf of Futis Biotech would be dealing with the second and the third contention. Now, Your Honor, before coming to the second contention, the Council would like to clarify few things. The question that was asked to my fellow co-counsel regarding the fact that now, Your Honor, could you please repeat that particular question that you had just asked to my fellow co-counsel so that I can give a broader clarity
you
on that
proceed with
particular
your
question.
contentions, and we'll ask as and when required.
Much obliged, Your Honor. Your Honor, the Council would it is hereby contended that the facts presented clearly and only mentioned that there was no drug in the market by the name of Viramgard, which was sold by Fetus Biotech. However, this does not amount to any validation to presume that the trademark hasn't been used in that particular time period, because the definition of uses is a broader definition apart solely based on the manufacturing and selling the data, selling the product physically. Now, Your Honor, in the case of Hardy Trading versus Addison Paint and Chemicals Limited, the Honorable Supreme Court of India had analyzed the aspect of usage and thereby held that use may be other than physical use, and it should not be merely limited to physical use of the goods or the sale of goods bearing that trademark. Now, Your Honor, the Council would like to bring another case given by very important judgment given by the Honorable Delhi High Court in the case of Ishi Khosla versus Anil Agarwal. Now, Your Honor, in this particular case,
Council, how would you justify your stand on the uses part?
Your Honor, this is a very important point that the Council is trying to make right now, is that the prop sheet is completely silent on the fact that whether we were at the year in which we were advertising our trademark, because the Council has n number of judgment and landmark judgment which clearly states that usage also includes advertising in different platforms. Now, Your Honor, this is to say that since the prop sheet is silent on the fact, therefore it would be very difficult to presume
What are your contentions? The fact sheet is silent on that. What are your contentions about uses?
Your Honor, we are of the Council are of the opinion that we were using the trademark not in the manufacturing or physical sales, but through advertisement in different portals. And what the prop sheet is talking about, the use of goods, that is only related to physical sale and manufacturing of goods under the trademark, which is one aspect of use. Use has two aspects, that is the physical use and the use in different newspapers and television ads through
Counsel, you're
advertisement.
inferring facts, you're contemplating facts. There is nothing written in the fact sheet that you have used this trademark for the advertisement and the promotions purpose.
Your Honor, this is the exact point what the Council is trying to state, that since the prop sheet itself is silent on the fact, it would be very difficult for the Honorable Court and especially for the respondent to prove that they were using the goods first. And they were of the
It is clearly mentioned in the fact that they were using the goods prior to your even applying for the same.
Much obliged, Your Honor. Your Honor, this is the very point that the council is trying to make. In the prop sheet is what the prop sheet is trying to say is they were using the goods physically, that is manufacturing and selling. Now, that is one aspect. The council agrees. But what the council does not agree is the whole definition of usage and the respondent taking advantage of the definition of usage and only stating half truth of the actual definition of usage and taking the defense of prior use under that umbrella. Now, Your Honor, the council would further go on to the fact and tell and would like to tell this honorable court.
I'll hold you here. Wait, means you are partially accepting that those guys were partially using the things before you started, right? You are partially accepting it.
Your Honor, there is another point which clearly states that if you are asking for a prior use defense, now council, give me 30 seconds. The council would rightly point the point that you are trying to make. In the second contention of the council from Fetus Batek, it is clearly mentioned that if you want to take the defense of prior use under section 34, you have to prove that you were manufacturing and selling your goods under this trademark within India. Now, Your Honor, in the prop sheet, in the factual matrix, you can clearly read that it is written that it was popular among its customers, the customers of Viram Institute, not among the customers or among the people of India. Now, the prop sheet is also silent on this fact. Now, if you can't establish the mere fact that you were manufacturing and selling your goods within India, then how can you take the defense of section 34, which is given under Trademarks Act of India, which is a statutory provision of India? You have to prove. And Your Honor, in that the very question that was asked to my co-counsel, I just got I had just remembered this question. Your Honor, it is very pertinent to note that we need to fulfill two criteria. First is and in the Preps Industries versus Kurlon Limited 2018 judgment, the Honorable Delhi High Court has given, you need to fulfill two criteria, and there is no rule that even if you fulfill one, the other you can let go the other criteria. Both the criteria should be fulfilled. First, there should be a consistent use. Now, Your Honor, the council agrees that this can be debatable about the fact that whether there is consistent use or not, because the prop sheet is saying that they were using since 2015, the respondent. So in that could be debatable. But Your Honor, what the other criteria is, and that can't be debatable, is that they have not produced any sales and manufacturing data. Any sales and manufacturing data has not been produced so far by them. And if only one of the criteria is not fulfilled, then also it will render the entire section voidable. You can't say that I have proven one criteria and the other criteria I may let go. You have to prove two criteria side by side simultaneously. Now, having said that, the council would like to come to the next sub-contention.
Yes.
Now, Your Honor, in this in the case of NR Dongre and others versus Whirlpool Corporation and others, this was clearly held by the Honorable Supreme Court that even if you are using a product since quite a long time, then you have to, again, this fact has already been given, that you have to prove that you are using the product within India and for the people of India, manufacturing and selling the product under that trade name. Now, Your Honor, the second sub-contention being that the trademark cannot be removed under section 47 if there was non-use by the Fetus Batek. Your Honor, this section 47 can't be used against us. Your Honor, let the council give two important and pertinent reasons for this. Your Honor, first reason is, having said that, and has already been mentioned, that the fact sheet is completely silent on the fact that which was the year as to whether we were on advertising, we were using the trademark through advertising platforms or not. Now, since the prop sheet is completely silent, the respondent can't take section 47 against us, as it clearly states that you should the other party against which you are initiating an action should not be using a particular trademark for a gap of 5 years. Now, in this particular case, Your Honor, if the council is to be believed that they were using the trademark through advertisement, then, Your Honor, this particular provision stands void, because then there is continuous use of that particular trademark and section 47 cannot be claimed. Now, this is the first condition of section 47. Second condition, Your Honor, is that you have to prove the malified intention of a registered trademark owner. If you want to remove the registered trademark owner from the register, you have to, second condition is under section 47 is that you have to prove their malified intention. Now, Your Honor, in this particular case, let the council further deliberate on the particular contention of intention. Intention is very important, Your Honor. Even when the respondent would be going and initiating an action of passing off against us, in that passing off criteria also intention plays a very important role. And also, Your Honor, in this particular section 47 of Trademarks Act, intention is given. Malified intention has to be proven. So in this particular case, Your Honor, let the council further go to another level and state
Council,
that
you are referring to section 47. What is it?
Your Honor, section 47 clearly states that if you want to remove a registered trademark from the registry, the following conditions are to be followed, and the conditions are laid down.
That is on the basis of non-use.
It is on the basis of non-use, and second, that you have to, if you are going for the removal of that trademark, you have to also prove that they have malified intention and they have wrongly registered their trademark. So both things need to be satisfied. So, Your Honor, in this particular case, what the council is trying to say is that council was using, the fact sheet is completely silent whether council was using the trademark in the form of advertisement or not. So in this particular case, the 5-year time period stands void because you can't prove, because there is no, the fact sheet is itself completely silent. The fact sheet is only talking about manufacturing or selling of goods, that is physical use of trademark, not the use of trademark through advertisement platform. That fact sheet is completely silent. So you can't say, or the respondent can't, beg your pardon, the respondent can't say that the appellant, that is Futus Biotech, was not using the trademark since 5 years. The 5-year period is not valid in this particular case, and the intention, Your Honor, if Your Honors would let me deliberate on the important contention of intention, the council would like to prove that if Your Honor would go and closely look into the factual matrix, it is given that the product description that is given by the respondent is completely same as that of the appellant, as that of our client Futus Biotech. Hence, we have done the registration prior to them. Second, when we filed,
was there already in market prior to your even applying for registration. So the description might be copied from there and by your pharmaceutical fintech.
The council would beg to differ from this, Your Honor. And how the council would like to prove that, Your Honor? Your Honor, in this particular case, we had first filed for the trademark, right? Now, while filing for trademark, we had given the product description. Now, what the respondent did, they filed first, they woke up from their sleep later on after we had registered, and then they tried to give the same product description. Now, the council would like to tell this honorable court what they are trying to do by giving the same product description. Now, Your Honor, what they are trying to do is that in future, if they launch any other product by the name of Viramgard, they can also sue us again and stating that, okay, look, we have the product description, we are launching, so for example, we are launching a sanitary napkin, and you have also launched a sanitary napkin, and since it is also Viramgard, you have also again used Viramgard. So then also they would try to put obstruction. Now, since they have cunningly, they have inserted
sorry to interrupt, but that can be the scenario for you too as well, right? You may also claim the same thing, and you may also allege them in the future for the several instances, right? You may also do the same thing which you are alleging upon them, right? You may also do. You should accept or denial. Is it? Huh?
Your Honor, it is a denial that we will never do this kind of thing. And why the council would give a reason for that also. Your Honor, the council had first given the product description. The council was the first party. Futus Biotech was the first party to give the product description. This means that we did not have any intention to obstruct them. They later on came with the same product description. If they came later on with the same product description, the onus is on them to prove that they have a malified intention or not us, because we were the first one to give the same product description. So we are honest in our intention. Now, Your Honor,
so
let me bring you with
who has a product. We are talking about the description. Who has the product?
Your Honor, this is the exact point what the council was.
Product?
No, Your Honor, the council is coming.
Who has the product?
The council is coming.
They are accepting that they are not having the product.
They don't have it.
Your Honor, what the council is trying to say is that we do have the product, but we have not manufactured or sold it physically. We are using it through advertisement. That is what the council is trying to say. And second point is that even
it is
though
not mentioned in the facts.
Your Honor, I totally agree. But you, Your Honor, the court has also to note this important fact that even though tomorrow we may launch a different product by this, so now since they have a same product description, the respondent won't come again to this court and drag Fetus Biotech in this particular case.
The Serum Institute. Viram Institute.
The Viram Institute.
It is the Viram Institute is a registered institute in 1960s, and they have a product around 2015, and after that in 2016. And you are a new company, and they have won many national awards as well, which has been clearly mentioned in the fact sheet. Also, they are been into this business, and they are selling the vaccines and even to international organizations as well, which has been clearly mentioned in this. You as a new institute, as a new corporation, in 2011 you begin your career, and in 2016 you registered a trademark for which there is no product, but there is a product similar to that which is already in market in 2015. Later on into 2020, when we are talking about it, till date you do not have any product, but they still have the product.
Your Honor, this is a very important question. The council would like to answer it very accurately and very on to the point answers. Your Honor, with your first grievance of that they were using the product since 2015. Your Honor, in the case of Ishi Khosla versus Anil Agarwal, the Honorable Delhi High Court has clearly stated that the year of usage is of no use. It doesn't matter if you were using it since 1990s, but you have to prove certain things. And what are those things? You have to prove that you were consistent user, together coupled with that you have produced sufficient sales and manufacturing data in front of this honorable court. Your Honor, again, now second point, Your Honor.
So by going to the general English term, where it has been provided by the fact sheet that they were using the product since 2015. What do you understand by this since 2015?
Your Honor, as the council had previously also mentioned this fact that this can be debatable. So the council is not going deep into this since 2015 fact. But what the council is going on to the matter is that they have not produced any sales and manufacturing data in front of this honorable court, and Your Honors are themselves witness to it. So, Your Honor, having said that, now the council would again like to mention one more important point that has been missed by Your Honors. Your Honors, if the company is selling its products and manufacturing its products to foreign countries and not within the people of India, if the company is not recognized by the customers of India, which is nowhere mentioned in the prop sheet, then they can't take the defense of Section 34 of Trademarks Act. As simple as that. So therefore, by this argument,
many national awards. They have won many national awards within the country. National award is given to the one who is serving the country. So they actually are serving the country in that matter as well.
Your Honor, on that argument, Your Honor, recently Amazon was also awarded the best startup encouraging company of India. So not of India, but by the India government. So Your Honor, that does not give to the fact that Your Honor, this is a very important fact that there might be a recognition by the government of India or by any NGO or by any other organization of India. But that recognition does not prove that this was a company manufacturing and selling its own product for the people of India. For the people of India is very important, Your Honor. This has to be proven. And if they are not able to prove this, that they were manufacturing their product for the people of India, they can't claim the defense of Section 34. Now, Your Honor, if Your Honors would be kind enough to give me time for the other contention to be mentioned in this honorable court. Now, Your Honor, since the council had already mentioned about this intention, malified intention that the respondent were having, they had not filed for the opposition. When we had filed for the trademark, we have, Your Honor, this is very important point. We have done our due diligence. We have done the trademark search. Even in the Google, we have typed the Viram Guard. And since they are not registered trademark, Your Honor, then even in trademark search, they wouldn't be able to, their name won't be appearing. So, Your Honor, we have done our diligence search. And now when the turn is on them, when the ball is in their court, they have not done any due diligence. If they had it been up to them, they would have searched this Viram Guard name in the trademark registry website, and they would have gotten our name, the fetus verdict, because we were already registered in 2018. They went for the registration in 2020. Had they searched the name and trademark website, the Viram Institute, Viram Guard, they would have gotten our name. So there could be two conditions, two scenarios from this condition. Either they already knew that we have registered, but still they went on to go for the registration. They never stopped in themselves, or else they have not done their due diligence. So even if they have done their due diligence, this means that they have seen that we have registered trademark. But even then, they have decided to go for it. So, Your Honor, in this, now that being said, the council would like to state the most important part of this particular contention. Your Honor, what the council is trying to state on behalf of Fetus Biotech is that they have already their drug name Viram Guard, right? Their Viram Guard is being used for mildly effective on COVID-19, right? Now, Your Honor, in this particular case, I would like to bring a scenario, a factual scenario in front of this honorable court. Now, Your Honor, this is a very important and interesting fact to note that AstraZeneca, which is a company manufacturing for COVID vaccines, they have two different names for same vaccines in two different countries. Now, Your Honor, if they have, the council agrees that they have established a very good reputation, although they have not established this fact that they have established good reputation in India, but the council agrees they might be having a good reputation outside India or to some other country or on a different level. So if the respondent really wanted to launch their product with a very bona fide intention, AstraZeneca, what this company had done is that the Vaxzevria is the same vaccine that is known by the name of Covishield in India. It is known by the name of Vaxzevria in UK, the Oxford vaccine, and the AstraZeneca company that has manufactured that, and it is known by the other name of Covishield in India. Now, Your Honor, not only this is the exact case of pharmaceutical companies and producing vaccine during the time of this pandemic, because the council very well knows that the respondent would try to take the defense of pandemic and they would try to create an extraordinary scenario. So, Your Honor, if Your Honors would be kind enough to refer to this particular issue and particular thing that happened with the AstraZeneca company, they don't have any problem. So what the council is trying to say is that if they want, they can even the case is sub judice regarding the registration. If they want, they can change their they can make changes in their
where you can show us the same.
Your Honor, much apologies, Your Honor. The council on behalf of Fetus Biotech does not have the compendium. But what the council is trying to make is a very factual thing, and this is the fact, and the council is not producing anything. It
must be proved on document. When it is on document, it has to be proved on document as well.
Your Honor, it is already been mentioned in our memorial, and also the fact that the council is not trying to presume anything. The council before this honorable court has only, the thing is, the council is trying to present facts. And also, Your Honor, one more important point. If they were so confident about their international reputation and their reputation within India, why did not they file their trademark registration under Rule 124 of Trademark Rules 2017, which provides for the protective umbrella of well-known trademarks? Why have they not filed a registration on the criteria under that category? This goes on to prove, Your Honor, that the council, the respondent were themselves not confident enough that their trademark were popular and enjoyed a sufficient goodwill and reputation. Now, Your Honor, this may be sufficient to prove that there is lack of intention. They are not sure about their reputation, and it is nowhere mentioned in the prop sheet that they were manufacturing their goods and services within India for the people of India. Now, Your Honor, this also automatically gives or bars them to take the defense of Section 34. Now, Your Honor, in this particular vaccine scenario that the Honorable Counsel had already mentioned, it is a perfect case for this particular scenario, since they are also manufacturing the COVID vaccine under the precious time and situation. Now, Your Honor, in this particular case of Preps Industries versus Kurlon Limited, it has also been held that it does not matter if you are using a particular trademark since 2015, the duration doesn't matter. And if any idea that is struck under the common mind or the extraordinary mind of the inventor, overnight that can become popular. And that can also enjoy the same reputation as compared to a goods which was enjoying the reputation since 2015. So the duration of year does not matter in this particular case. Now, Your Honor, the counsel would like to come to the final contention, that is that the respondent be ordered injunction and other requisite remedies. Now, Your Honor, it is pertinent to note that both civil and criminal remedies can be given to the appellant against the respondent. Your Honor, in this particular section 103 of Trademarks Act, it clearly mentions that if one of the other party tries to initiate or imitate a trademark similar to the other party, to the party that has already been registered its trademark, then it should be punishable with an imprisonment with a minimum of 3 months that should not extend to 3 years. Now, Your Honor, this is to be very specific that we have our primary four damages that we want that the court should grant to us, and 4 remedies that the court should give to us. That is permanent injunction or stay against the use of trademark, appropriate damages, handing over the accounts of profit. Your Honor, we want account of profit from 2016 till this date, and the appointment of a local commissioner by the respective court for custody of sealing of infringing materials, and the punishment under Chapter 12 of the Trademarks Act. Now, Your Honor, if Your Honors may be kind enough, the counsel would like to come to the prayer and the submission. Now, Your Honor, in the light of the facts of the cases, issues raised, arguments advanced, and authorities cited, the counsel on behalf of the appellant humbly prays before this Honorable Supreme Court to kindly adjudge and declare that there is trademark infringement under Trademark Act by the respondent, that the appellant is a user of the trademark and has the right to use the trademark, and the respondent has no ground to take the defense of prior uses, and that the respondent be ordered injunction and pay damages to Futus Biotech for the loss caused. To pray and any appropriate relief as the court may deem fit, and for this act of kindness, the counsel on behalf of Futus Biotech shall forever pray.
So you're claiming injunction.
Much obliged, Your Honor.
So how balance of convenience is in your favor?
Your Honor, as as can be inferred from the fact that the counsel would like to state that there is Trinity rule when it comes to the granting of injunction. So, Your Honor, as one of the important condition is that the damage to the reputation, and therefore, Your Honor, it is to be contended that the appellant has the reputation of the appellant has been there has been damage to the reputation of the appellant, and since the appellant has already been working on various products, and the time has also been wasted of this honorable court as well as the appellant, that is why the counsel firmly believes that there should be an injunction, because, and henceforth also not to forget that if there is no injunction passed today, then in future as already been mentioned by the council from the Futus Biotech, they would be launching another product because they have same product description as ours, and they would claim for trademark for that product also, and the losses would be irreparable in future also. So, Your Honor, likelihood of damages is also an important criteria that should be kept in mind while deciding this.
Counsel, have you considered the judgment of the Supreme Court in the case of Milmeth Opto versus Allergan, which says that the prior user has to be prior at any point of time in the world, especially in pharmaceutical products? Since Veramgard has used it prior and point of time, what is your response to that?
Your Honor, the council in its previous argument has already disputed the fact that whether they are prior user or not, merely on the basis of the fact that they have to be a company manufacturing goods and services for the people of India and not to any other foreign country, because they are taking the defense of Section 34, which is for the Trademarks Act of this country and the statutory rights of this country.
That's why I mentioned the judgment which says for pharmaceutical products, it has to be prior in any country of the world. Also, to add to that question, the corporate name of the respondent contains Verum as a part of its name, and corporate name or a trade name forms part of a trademark. Will that not be considered as a trademark used by the respondent prior and point of time in India?
Your Honor, coming to your first point, the council would like to answer that in Chorus Limited versus Wales Stationery Products Limited, the Honorable Court had held that the defense of prior use under Section 34 applies to a situation where a person has continuously used a trademark from a date prior to the use of a registered trademark in relation to those goods and services by the proprietor of the mark prior to the date of registration of the mark within the territory of India. Now, Your Honor, it is also pertinent to note that there can be a different interpretation on different case laws, but what the council is trying to mention is that in the present scenario, the council had also given a factual example of the situation, the AstraZeneca company, which is rightly doing which is rightly going with two different names of same vaccines in two different countries. So, Your Honor, there should not be a problem for the respondent to change the name even with respect to manufacturing certain goods within India. They could change the name. They could change the trade name,
for the
and they can continue with
to decide. No, AstraZeneca as a company chose to have two different names.
Your Honor,
the respondent has been using Verum for so long.
Your Honor,
compel them?
Your Honor, what the council is trying to say is that if AstraZeneca being the same pharmaceutical company that the respondent is also, and if they can go ahead with changing the name of their vaccine and they are comfortable with this, the same precedent should be followed. That is the only point that the respondent that the applicant is trying to mention. And this is of recent case. This is of 2021. In March, they have announced a new name. Vaxivera, that is the name that for the vaccine that is used in UK. So, Your Honor, this is what the council is trying to highlight is that there is no big issue in changing the trademark name. The respondent can easily do that. And also, with regard to that, they were using since 2015. So, why should they change their name? That has already been pointed by the council that the duration does not matter. In the Isha Khosla case, the Honorable Delhi High Court has already stated that if an idea and if a product is made overnight hit because the social media, and the Honorable Delhi High Court has observed during the age of social media, anything can be viral. So in that particular case, the same product would enjoy equal reputation and equal reputation as compared to a company or a product which has been using since 5-10 years. So the duration doesn't matter. In this particular case, the Honorable Delhi High Court tried to put the distinction between the fact and establish the fact that the duration does not matter. What matters is that if a product is been derived naturally, if the product has been invented, if the product has certain distinctiveness. Now, Your Honor, with that particular question, verum is a Latin word which means truth. Now, Your Honor, we have done a diligent search in the trademark registry also. We have not found any name by Veramgard, and that is the reason why we went ahead with this name. Now, Your Honor, when the time came for the respondent to do the diligent search, they did not, because had they done the diligent search, our name would have appeared in the website. but they did not. Either they did or either they did not. Now, if they did, and if the name appeared, but they still decided to go on with it, this means that they have malified intention. No, Your Honor, this has to be established by the respondent. The council has given sufficient analogy to this particular case.
Thank you.
The council seeks permission to approach the dais. Much obliged. The council is appearing on behalf of the respondent. The council seeks permission to address the dais as your lordship. The council would like to proceed with the statement of jurisdiction. Your lordship, the appellants cannot appeal before the Honorable Supreme Court under Article 133 as a certificate from the High Court is mandated under Article 133. Only then an appeal can lie to the Supreme Court. Also, Clause A mentions that there must be a substantial question of law present. The Honorable Supreme Court on 27 August 2020 in the matter of Nazir Mohammed versus J. Kamla and OR others pronounced that to be substantial, a question of law must be debatable, not previously settled by the law of the land or any binding precedent, and must have a material bearing on the decision of the case or the rights of the parties before it, if answered either way. Here, in the present case, there is no substantial question of law, and there are binding precedents that say that prior users' rights are superior to that of the registrar. Further moving, if the court is well versed with the facts, the council would like to proceed with the issues.
Yes, please.
Much obliged. The council seeks permission to proceed with the issues. First, whether the Viram Institute is infringing the trademark Viramgad violating Section 29 of the Trademarks Act 1999. Second, whether the court can issue an injunction upon Viram Institute restraining and prohibiting them from using the mark Viramgad under Section 135 of the Trademarks Act 1999. Third, whether Viram Institute is passing off the registered trademark Viramgad under Section 135 of the Trademarks Act 1999. Fourth, whether the court can grant damages to Futus Biotech for usage and infringement of its registered trademark under Section 135 of the Trademarks Act 1999. Fifth, whether the registrar can refuse granting of the registration of the trademark to Viram Institute under Section 23 read with Section 34 of the Trademarks Act 1999. My submission will address issue number 1 and 3. The council seeks permission to proceed with the arguments.
Yes, please.
It is humbly submitted that the Viram Institute is not infringing the trademark Viramgad. The council will sail the court through 3 points which will prove that the respondents are not infringing the trademark and hence not violating Section 29 of the Trademarks Act 1999. It's undisputed that Section 29 of the Trademark Act 1999 confers upon the registered proprietor of the trademark certain rights, but a reading of this section manifests clearly that these rights conferred are not absolute. The rights are subject to conditions and limitations. Thus, owing to Section 28, the applicants in the present case do not have an exclusive right to use the trademark Viramgad, as the said section is subject to the conditions and limitations mentioned in Section 34 of the Trademarks Act 1999. Section 34 entails the rights of the prior user. The Supreme Court in S. Said Moideen versus P. Sulochana Bai has correctly observed that collective reading of Sections 27, 28 and 34 would show that the rights of the registration are subject to the rights of the prior user of the trademark, that is Section 34, which can be seen from the opening words of the Section 28 of the Act, which states, subject to the other provisions of this Act, the registration of a trademark shall, if valid, give to the registered proprietor. And also the opening words of Section 34, which states, nothing in this Act shall entitle the proprietor or a registered user of registered trademark to interfere. Thus, the scheme of the Act is such that rights of the prior users are recognized superior to that of the registration, and even the registered proprietor cannot disturb and interfere with the rights of the prior users. This proposition has also been discussed in extension by the Honorable Divisional Bench of Delhi in the case of N.R. Dongre and others versus Whirlpool Corporation and ANR, wherein it recognized that the registration is not an indivisible right and the same is subject to the rights of prior user. This decision was further affirmed by the Supreme Court in the case of N.R. Dongre and others versus Whirlpool Corporation and other. The same has been affirmed in the subsequent decisions of the Supreme Court, one of which is the case of Neon Laboratories Limited versus Medical Technologies Limited and others. Further, it is pertinent to note that the applicants in the present case had filed the trademark application of Viramghat in March 2016 and the same was granted to them on 1st January 2018. On the other hand, though the respondents applied for the trademark on 1st July 2020, they had already a drug in the market since 2015, which is being sold under the name Viramghat since then. It's mentioned we have used since 2015, which means we have been using it continuously since then. This clearly goes on to show that the respondents are the prior users of the trademark Viramghat. Therefore, this reasoning gives clear indication that the rights of the prior user are superior than that of the registration, and since the rights of the respondents are unaffected by the registration rights under the Act, the use of the mark Viramghat is bona fide. Thus, the respondents are not infringing the trademark Viramghat. Secondly, the use of the mark Viramghat by the respondents has neither caused deception or confusion, nor is it likely to cause deception or confusion. To support this, we make a reference to the case of Anshul Industries versus Shiva Tobacco Company, wherein the Delhi High Court held that question of confusion cannot be decided by keeping the two marks by each other and noting similarities and differences between the two marks. Right in a trademark is with reference to trade and commerce. Question of deception and confusion has to be examined and dealt with from a commercial point of view. The law gives protection to the proprietor of the trademark if there is likelihood of deception or confusion. The impression created by looking at the two marks and the significant feature and the idea behind the two marks that would be formed in the mind of the purchaser is the relevant criteria. In the present case, there is no likelihood of deception or confusion because the only drug being sold in the market by the name of Viramghat is of the respondents. Also, the name Viramghat is associated by the customers with Viram Institute. Hence, only the impression of the mark of the respondents is created in the minds of the purchasers. When examined with a commercial point of view, the question of deception or confusion in the mind of a normal consumer does not arise at any moment. In absence of such deception, a case of infringement is not made out. Thirdly, the council submits that there has been no continuous and sustained use of the mark Viramghat by the applicant since they have registered the trademark. In support of this, we make a reference to the case of Corn Products Refining Corporation Limited versus Shangri-La Food Products Limited, wherein the Supreme Court held that it is not permissible to draw any inference as to use from mere presence of the mark on the register. To sustain an action of infringement, it is imperative to exhibit continuous and sustained use of the mark to demonstrate that it has acquired distinctiveness. The Delhi High Court in Virumal Praveen Kumar versus Needle Industries India Private Limited emphasized that a trademark does not arise from the mere use of a word or words or a formula or a mark. It had to be shown that in relation to particular goods, there is a course of trading and that a goodwill connecting the trader with the goods by reason of the trademark under which the goods are marketed has resulted. It was observed that, quote, it follows that where in relation to particular goods, there is no such cause of trading as to give rise to goodwill, there is no interest to be protected by a trademark, and such mark can subsist in and no such mark can subsist in vacuum. Unquote. We also make a reference to the case of Dr. Reddy's Laboratories Limited versus Aeros International Media Limited, wherein the court affirmed with the decision of Supreme Court that the mere presence of a mark on a register would not lead to automatic success in an action for infringement. And it was imperative to demonstrate continuous and sustained use of the mark to exemplify its distinctiveness. In the present case, although the applicants have registered the trademark and the mark Viramgad stands in their name, there has been no commercial use of the said trademark by them. In other words, the applicants have applied to exhibit continuous and sustained use of the mark. In absence of continuous use of the trademark Viramgad by the applicant, the suit of infringement cannot sustain. Thus, Viram Institute is not infringing the trademark Viramgad and is not violating Section 28 of the Trademarks Act 1999. If your lordships are satisfied, the council seeks permission to proceed with the second issue.
Yeah, proceed.
Much obliged. It is humbly submitted that Viram Institute is not passing off the registered trademark Viramgad, where pertaining to the issue that whether Viram Institute is passing off the registered trademark Viramgad under Section 135 of the Trademarks Act 1990. Firstly, because the requirements under subsection 3 of Section 135 have been satisfied by the respondents, Section 135 of the Trademark Act prescribes the relief to be granted by the court in case of passing off. But subsection 3 sets out an exception that if the defendant satisfies the court that he was unaware and had no reasonable ground to believe that the trademark was in use by the plaintiff, and when he became aware of the existence, he ceased to use the trademark in dispute, the court shall not grant relief. The council submits that the respondents at the time of commencement of using the trademark had no reasonable ground of believing that the trademark for the plaintiff was in use, as they have adopted the trademark in 2016, whereas the respondents have started using in 2015. As proved earlier, the respondents were the first to use the trademark, or as the plaintiff has no drug being sold under this name, the question of believing that trademark for the plaintiff was in use does not arise at any moment. The respondents are using
Counsel, why did you not approach the registry for the registration before? It is just, the time of pandemic, you have approached. Might be you have got to know that the petitioners have the registration and now you want to encash on their, registration.
Your Lordship, registration gives international property rights, which aids in increasing finances. Now the respondents need finances because they are producing drugs which is supplied to international organizations and which is very helpful to get over this pandemic. So the registration of the trademark is needed for the finances.
Okay, go ahead.
But that also does not justify your sleeping over your rights. You could have filed for an objection as well. Since you have a name, Viram Institute, and somebody is from the same field is trying to register some product by the same name, having the similarity in the name, you could have filed for the objection. Why did you sleep over your rights? What is the justification for that?
Your Lordship, the respondents have not slept over the rights. However, they have the
Till
right.
date, you have not filed an objection against that. Neither you went to the court approaching court to grant you injunction on the same right, same trademark.
Your Lordship, the respondent can object the registration of the appellants now on the ground that they haven't used the trademark on the ground of non-use. It must be rectified, and also there is no bar of limitation as the act. It is nowhere mandated that the respondents cannot cannot object and cannot take action against the the registered trademark afterwards. So it is not mandated anywhere.
Have you reserved your right to initiate a cancellation against their registration in your pleadings?
Your Lordship, this issue will be taken by my co-counsel in her argument.
Okay. All right.
The respondents are using the trademark prior to the plaintiff, and such a prior user is required to be protected because the person using the trademark prior to the user of the trade name, like plaintiff would not know in the future somebody else is going to use his trademark and start the business as observed in Vanita Dilip Chawla versus Fresh Meals India Private Limited. Further, it is submitted that respondents did not cease the usage of the trademark after becoming aware of the existence and nature of the applicant's trademark, as they were the prior users and they are on the higher pedestal. As it is a well settled principle of the trademark that the rights of the prior user are recognized superior to that of the registered, as recognized it by various cases in various cases, by various courts in various cases. In addition, it is a well-settled law that even a registered proprietor of a trademark can be restrained from using a trademark in passing of action on the basis of prior users, as observed by the Supreme Court in N.R. Dongre and others versus Whirlpool Corporation and others on 30th August 1996. Secondly, the classical trinity test as prescribed by the House of Lords in the case of Reckitt and Coleman Products Limited versus Borden Inc. has to be satisfied to constitute a case of passing off. This has been subsequently upheld by the Indian Supreme Court in the case of Lakshmikant versus Patel. In this case, the classical trinity of passing off has not been satisfied, which comprises of three elements, namely goodwill, misrepresentation, and damage. So considering the first element, it is submitted that applicants have not successfully shown that there is goodwill owned by the applicant. The goodwill is an intangible asset that cannot be easily defined. In the words of Lord Magden, in the case of Inland Revenue Commissioner versus Muller and Corporations Marketing Limited, can be described as it is a thing, very easy to describe but difficult to define. It is the benefit and advantage of the good name, reputation, and connection of a business. It is the attractive force which brings in customers. It is the one thing that distinguishes an old established business from a new business at its first start. The goodwill of a business must emanate from a particular center or source. However widely extended or diffuse its influence may be, goodwill is worth nothing unless it has the power of attraction sufficient to bring customers home to the source from which it emanates. Goodwill does not have a particular definition, but it has nexus with the reputation of the goods or services related to the product. The Delhi High Court has opined in the case of Baker Youth Limited versus Hero Kushlani that in order to establish a claim in passing off, the plaintiff must be able to establish that it has necessary goodwill and reputation in the goods sold or services offered to the customers at large. Here, they fail to do so. Also, the second element, that is misrepresentation, is an essential element.
Apply for passing off?
Can
you differentiate between the passing off and infringement of trademark?
Your Lordship, though they haven't alleged passing off on Viram Institute, but the respondents were very concerned about their clients, so they are proving that even Viram Institute is not passing off their.
Can you differentiate between passing off and infringement of trademark?
Your Lordship, an action for infringement can be constituted only by a registered proprietor of a trademark, whereas passing off can be initiated even though the proprietor has not registered its trademark. And
so in this present case, are they eligible to apply for passing off, or since they have a registered trademark and you don't have one?
Your Lordship, they haven't alleged us, the respondents, for passing off that, but the respondents were concerned about their clients, so they are proving that even a passing of action um, cannot be initiated, as they failed to prove the three elements, that is classical trinity, which is essential in the passing of action.
You can.
Your Lordship, the third element that also has not been satisfied by the applicant, and that is the likelihood of damage to the goodwill by the respondents. It has been opined again in the case of Baker Hughes Limited versus Kiru Kushlani that in
Okay,
order to
we got
establish,
your point. This point, you can proceed to the next.
hence it is proved that the Viram Institute is not passing of the registered trademark Viramgad under Section 135 of the Trademark Act 1999. Um, Your Lordship, the appellants had mentioned in their arguments that classical that the respondents are selling their goods as other parties, and classical trinity test was also mentioned in their arguments. It was an honor to present the issues before this honorable court. My co-counsel will further deal with the remainder issues.
Your Lordships, the Council seeks permission to proceed with further issues.
Yes.
Council will be dealing with issue number 2, 4, and 5 in the memorial. The third issue is whether the court can grant an injunction upon Viram Institute restraining and prohibiting them from using the mark Viramgad under Section 135 of the Trademark Act 1999. Section 135 of the Act provides the relief of injunction in a suit of infringement. Any injunction granted by the court under Section 135 should be justified in accordance with the test prescribed by House of Lords in the American Cyanamide case 1975. Your Lordship, the Council would also mention that the Council for the petitioners mentioned that in a case of injunction, the respondents have to satisfy the classical trinity test. However, the classical trinity test has to be satisfied in the case of passing off and not injunction. For injunction, the test prescribed is laid down in the case of American Cyanamide case, which the Council for the respondent would be relying on. This test has been upheld in the decisions of Supreme Court, such as Wonder Limited versus Antox India, Gujarat Bottling Company versus Coca-Cola and others, Lakshmikant Patel versus Chetan Bhatt Shah and others, and other subsequent decisions. The test prescribed in the case is, first, there needs to be a prima facie case. The applicant must make out a prima facie case. It was held in the American Cyanamide case that a prima facie case would be made out if the plaintiffs raised a serious question to be tried. Honorable Supreme Court in Dalpat Kumar and others versus Prahlad Singh and others has observed prima facie case is a substantial question raised bona fide which needs investigation and a decision on merits. In the present case, the applicants have pleaded a case of infringement. As argued by my co-counsel, no case of infringement can be made out as the respondents are the prior users of the mark, and the registered proprietor cannot disturb and interfere with the rights of the prior users by virtue of Section 34. Additionally, it is established fact that the customers associate the mark Viramgad with Viram Institute. While the respondents have been continuously using the mark Viramgad, the applicants have not used the mark till date as they do not have any product of this name in the market. Without showing that the mark of the applicant has been infringed by the respondents and that the goodwill or reputation of the applicants is in danger because of the use of the mark Viramgad by the respondents, the applicants have not raised a serious question which needs investigation and a decision on merit. Thus, the requirements of prima facie case are not met here, and hence it is submitted that there is no prima facie case to be tried before this court. The second condition is that of irreparable injury. It must be shown that the applicant will suffer irreparable injury if the court refuses injunction relief. The Supreme Court in Dalpat Kumar and others versus Prahlad Singh and others defined irreparable injury as an injury that must be a material one. namely one that cannot be adequately compensated by way of damages. First, according to this definition given by the Supreme Court, irreparable injury is required to be material in nature. In the present case, due to non-use of the mark Viramgad by the applicants, there is no material injury caused to them by the use of the mark by the respondents, as the question of possible losses or loss of goodwill or reputation does not arise at all. Secondly, the applicants must make out a strong case that the defendant's action materially injure its business. There is no material on record brought by the applicants to indicate that their business has suffered after the defendant started its business. Additionally, the adoption of the mark Viramgad by the respondent is neither misleading the customers nor causing any confusion. Thus, the use of the mark Viramgad by the respondent is not causing imminent danger to the business of the applicants. Thirdly, in Shelke Beverages Private Limited versus Rasiklal Manikchand Dariwal, the court held that unless it is prima facie shown that the plaintiffs have suffered actual losses due to alleged unlawful acts of the defendants using or infringing their trademark, grant of interim injunction cannot be justified, as speculative or unproven damages cannot be considered. In the present case, proof of actual loss must be brought on record by the applicants. In absence of such proof, irreparable injury cannot be based on potential future losses. Therefore, the grant of injunction in the present case does not cause any irreparable injury to the applicants. Your Lordship's third condition is that of balance of convenience. For the grant of injunction, there is a requirement that the balance of convenience should be in the favor of the applicant. The court must be satisfied that firstly, the comparative hardship or inconvenience which is likely to occur from withholding the injunction will not be greater than that which would likely arise from granting it, and secondly, whether the injunction will impact the public at large. Honorable Supreme Court in Dalpat Kumar and others versus Prahlad Singh and others has held that the court must weigh one need against the another and determine where the balance of convenience lies. In the instant case, the government of India had urged pharmaceutical companies to undertake research seriously on a priority basis and develop a medicine to treat the virus impact. The government had permitted it to undergo clinical trials as well. On the other hand, the applicants have not been using the Viramgad and no product of this name is in the market. The respondents have already established their goodwill. Thus, no hardship or inconvenience will be caused to the applicants because the injunction will not change their status quo. Whereas the respondent's business and reputation will suffer serious harm if the injunction is granted. Thus, the council submits that the comparative hardship or inconvenience which is likely to occur from withholding the injunction will not be greater than that which would arise from granting it. Furthermore, in the decision of Anshul Industries versus Shiva Tobacco Company, it was held that while examining the question of balance of convenience, court is required to take into consideration public interest of the buyers and consumers. The mark Viramgad is used by the respondents in respect of a drug developed by it to treat the deadly virus COVID-19. This drug, Viramgad, is now widely known among the customers and the trade channel. A temporary injunction directing Viram Institute to discontinue the use of the mark Viramgad for its drug will cause confusion and disruption in the administration program of the state. In this case, thus, the grant of injunction would have large-scale ramifications traversing beyond the parties to the suit. Hence, the grant of injunction in the present case will not be in public interest. Therefore, it is submitted that the balance of convenience is not in the favor of the applicants. In addition to this test, Your Lordships, the Council also submits that in the case of Series 5 software versus Clark, the court held that in trademark matters, it is now necessary to go into the question of comparable strength of the cases of either party, apart from balance of convenience. This view of the court in Series 5 case has been upheld by the Supreme Court in Colgate-Palmolive versus Hindustan Lever, SM Daicham versus Cadbury India. While examining the question of comparable strength, it is pertinent to note that the respondents have proved the prior use of the mark Viramgad. They are thus entitled to protection. Moreover, the respondents have been putting in enormous efforts and painstakingly working towards upgrading their mark. This has resulted in popularity and reputation of a high order to the respondents. COVID-19 drug Viramgad has become synonymous with respondents. Thus, there appears no likelihood of confusion or deception. These factors would have a bearing on the comparable strength of the respondent's case, which has to be taken into account while considering the prayer for grant of injunction. On the contrary, the applicants have failed to establish the strength of the case, since priority in adoption of and use of the trademark is superior to priority in registration. In absence of commercial use by the applicant and no advertisements, their reputation is not established. When all the factors are considered cumulatively, the applicants do not have a strong case to prove the need for an injunction. Therefore, in light of the facts and circumstances of the instant case, the comparative strength of the case of the respondent is more than that of applicants. The council thus concludes that the court cannot grant injunction as the three-part cumulative test laid down in the American cyanamide case is not satisfied, the principle of comparable strength laid down in the Series 5 case is not satisfied, and the grant of injunction is not necessary to protect third parties. Thus, the court cannot grant injunction in this case. If your lordships are satisfied with this issue, the council would move forward with the next issue.
Yes.
Much obliged, your lordship. Well, the next issue is whether the court can grant damages to Futus Biotech for usage and infringement of its registered trademark under Section 135 of the Trademark Act 1999. Your lordship, the requirements for grant of damages or account of profits are given under Section 135. First, the court cannot grant damages to the applicants as the requirements under subsection 1 of Section 135 are not satisfied. Subsection 1 of Section 135 reads as the relief which a court may grant in any suit for infringement or for passing off referred includes injunction and at the option of the plaintiff either damages or an account of profit. The bare reading of this section makes it clear that the court may grant damages in any suit for infringement or for passing off. However, as has been argued before, the rights of prior users are superior to that of the registration by virtue of Section 34 of the Act, and even the registered proprietor cannot disturb or interfere with the rights of the prior users. The claim for infringement cannot be made out against the respondents. Also, the claim of passing off cannot be made out against the respondents as the classical Trinity test has not been satisfied. Thus, no suit for infringement or passing off lies against the respondent in the present case, and in such circumstances, the court cannot grant damages or accounts of profits to the applicants by virtue of subsection 1 of Section 135. Secondly, your lordships, the requirements under subsection 3 of Section 135 are satisfied by the respondents. As argued by my co-counsel, the two requirements mentioned under subsection 3 of Section 135, which are the respondent at the time of commencement of using the trademark had no reasonable ground of believing that the trademark for the plaintiff was in use. The second condition is that the respondent did not cease the use of the trademark after becoming aware of the existence and nature of the applicant's mark, as they were the prior users. Therefore, by virtue of satisfying these requirements as per subsection 3 clause B, read with subsection 3 clause C, the court shall not grant relief by way of damages or an account of profit in any case of infringement or passing off. Third, the applicants have not suffered any material losses. The applicants have not used the mark Virumgard since 2016, since they filed for application. Additionally, they have neither spent any amount to promote the mark nor put in any efforts to upgrade their brand. As the applicants have not popularized the mark Virumgard, they have not received any goodwill or reputation. It is submitted that the respondents who are in business since 2015 regarding the trademark Virumgard have not made any illegitimate profit at the expense of the applicant's reputation or goodwill. Thus, Futus Biotech has not suffered any losses as they do not have the product in the market under the same name, under the name Virumgard. Your Lordship, in light of these arguments presented before this honorable bench, the respondents are not liable to pay damages to the applicants. If your Lordships are satisfied with this issue, the Council would move forward to the last issue. Much obliged, your Lordships. The last issue is whether the registrar can refuse granting of the registration of trademark to Viram Institute under Section 23, read with Section 34 of the Trademark Act 1999. The Council humbly submits that the registrar cannot refuse granting of registration of trademark to Viram Institute because of the following reasons. First, as per the provisions of Section 34, the respondents clearly qualify as prior users of the mark Virumgard. Clause B of section 34 states that if any person has been continuously using a mark which is identical to a registered trademark from a date prior to the date of registration of the first mentioned trademark, then the registrar shall not refuse to register the second mentioned mark by reason only of the registration of the first mentioned trademark. Applying this section to the facts of the present case, it is clear that although the trademark Virumgard stands in the name of the applicants, such registration does not give them protection against the prior users of the mark Virumgard, that is the respondents. Thus, by virtue of this section, the registrar cannot refuse to register the mark of the respondents, even though it is identical to the mark of the applicants, merely by the reason of registration of the mark of the applicants. Your lordships, secondly, it is submitted that the registered trademark of the applicant is deemed to be removed from the register on the ground of non-use. As per the provisions of section 47B of the Trademark Act, a registered trademark may be taken off the register in respect of goods or services in respect of which it is registered if for a continuous period of 5 years from the date on which the trademark is registered, or longer period has elapsed during which the trademark was registered and during which there was no bona fide use thereof in relation to those goods or services by the proprietor thereof for time being. The council also makes a reference to section 23B, which states that when an application for registration of trademark has been accepted, the registrar shall register the said trademark, and the trademark, when registered, shall be registered as the date of making the said application, and that date shall be deemed to be the date of registration. By virtue of this section, the date of application for the registration of the trademark will be deemed as the date of registration. In the present case, the applicants filed a trademark application in March 2016. Accordingly, the date of registration will also be March 2016 by virtue of section 23B. Under section 47B, there is a requirement that a period of 5 years must have elapsed from the date of registration. Since the date of registration of the applicants is March 2016 as proved by the council, a period of 5 years has elapsed. The second requirement under section 47B is that for a continuous period of 5 years, there should be no bona fide use thereof in relation to the goods or services registered. It is submitted that the applicants have not used the mark Virumgard in respect of goods till date. Thus, the registered trademark Virumgard can be taken off by the registrar by virtue of section 47B read with section 23B. Hence, the registration of the mark of the respondents cannot be denied. Additionally, the respondent has not been a bona fide user of the mark Virumgard. This could be witnessed from the fact that they've not put in a single product in the market since they applied for registration or when they got registration, which indicates that the purpose of putting the Viram Institute, which indicates that the purpose was of putting the Viram Institute in a conflicting position by getting the mark registered and displaying an absolute non-usage of the product for significant period of 2 years clearly indicates the unintentional registration without a purpose to hold. Additionally, the council would also like to make mention of the section 12, which lends protection to cases of bona fide concurrent usage of the same trademark by more than one user. Section 12 of the Act reads as, in case of honest concurrent use, or the registrar may permit the registration by more than one proprietor of the trademark which are identical or similar in respect of the same or similar goods or services. Now, to take
you are claiming that you both were the concurrent users. Is it what your submission is?
Indeed, not, your lordship. Now that the council has proved that the mark of the
well, you yourself, if you are using this, then you yourself are acknowledging the fact that the petitioners are the concurrent users.
Your lordship, the council is trying to make a point that the registrar cannot deny the mark because the respondents can also be because the respondents are honest users according to section 12. And now that the council has
section 12 is for honest and concurrent user. So you are claiming that section.
Your lordship, the council is not claiming that section. It is just an additional point to make the case even stronger, that the registration cannot be denied to the respondents.
So what is your stand that either you are prior user and they are the subsequent user, or you both are the concurrent users, or the non-use, as you have mentioned that the cancellation of the registration on the basis of non-use. So what is your stand? Please clear it.
Indeed, Your Lordship. Your Lordship, the stand of the council is that the respondents could have been concurrent users. However, now that the council has proved that the trademark of the applicants can be taken off the register, they cannot be concurrent users, and now the only users can be the respondents, because they have honestly used the mark since 2015.
Go ahead.
Your Lordship, the only point that the council is trying to make is that there must be honest use of the mark from the initial stage itself. It is, and for honest use, it is necessary to show that commercial use of the mark, and that such use must be for a considerable period of time. The court, it is hence the contention of the respondents that they have commercially used the mark Viram Guard since 2015, and hence the use by them has been honest. Your Lordships, the council would thus conclude by saying that the registration of the mark Viram Guard cannot be denied to the respondents. If your Lordships are satisfied with the issues, the council would move forward with the prayer. Much obliged, Your Lordships. Whereof, in the light of issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully requested that this Honorable Supreme Court of Vidya to adjudge and dismiss the present appeal and pass any other order, decree, or judgment that this Honorable Court deems fit in light of justice, equity, and good conscience. For this act of kindness, the respondent shall be duty bound forever. It was an honor presenting the issues before this honorable bench.
Madam Counsel, I had asked a question to your co-counsel earlier. Have you reserved your right to initiate cancellation against the registration by the appellant in your pleadings?
Indeed, your Lordship, the council mentioned that a period of 5 years has elapsed, and after that a period of 3 years, 3 months also needs to be elapsed for the respondents to file the application. The period has elapsed only in July 2021, and which is why the respondents would now file an application to take off the mark of the register from of the applicants.
My question was, have you reserved your right to initiate a cancellation in your pleadings, or is it only during oral arguments that you're taking this plea?
Your Lordship, yes, we did reserve the right, and it is also mentioned in the written submission.
Can you point it out to me, please?
Indeed, Your Ladyship. Your Ladyship, just a second. The council is trying to find the page number.
Madam Researcher, help her out. I'm only asking this question because when you consider IP laws, you have to see Code of Civil Procedure also. There's a concept of Order 2, Rule 2. If you don't plead something or reserve your right to do something, Order 2, Rule 2 may come in your way. I just want to make sure that you've pleaded.
Your Ladyship, The council only mentioned about this section just to because the suit is about infringement and the petitioners are the applicants are trying to make a case that we have infringed their trademark, and which is why we just wanted to make sure that the case of the clients is strong. So we wanted to point it out that their mark can be taken off the register.
But you've not taken any steps to do that.
Indeed not, your ladyship, because the period has only elapsed in July, which was last month. The clients would definitely take up a step to take off from the register. Your ladyship, it is mentioned on page number 32 of the written submission. 5.3, subpoint 5.3. Much obliged, your ladyship.
Okay. Thank you.
If your honors may allow, may the council on behalf of the appellant go ahead with the rebuttals.
Yes.
Much obliged, your honors. Your honors, to begin with, the council humbly contends the fact that in their written submission, they've clearly submitted to the jurisdiction under Article 133, Clause 1, and this should not contrary and go contrary to their points themselves. And so, as the council has already endeavored to establish that the jurisdiction is definitely maintainable in the present case, as it's clearly written in the factual matrix itself, that the matter is sub judice in the Apex Code, thus implying the fact that the certificate of under 134A must have been granted by the Honorable High Court of Rajapur, so that the Honorable Supreme Court of India
that you have already argued. Any other point of?
Indeed, your honors. The council is glad that the point's been taken into consideration. Second is that, your honors, the respondents submitted that they need finances for their medicine right now, and so they are getting registration now, and that's in 2020. However, your honors, the council submit this an assumption, and it's not clearly mentioned in the facts of the case. And even if we agree to the same, that implies that prior to this, they weren't using it continuously and consistently. If they need finances now, if they need registration now, that implies the fact that they might not have needed the finances prior to this and might not have consistent use as the requirement of prior user. And to allay all the doubts, your honors, the council humbly submits that they might have relied upon certain assumptions in arguendo. And to allay all the doubts, the council humbly requests the Honorable Court to kindly refer to page 4, paragraph 4 of page 2. If we are on the same page, your honors.
Yes, mentioned.
Much obliged, your honors. The last line of this paragraph states that the registration was granted to them on 1st January 2018, and the Futus Biotech, and although it's written clearly that no drug was in the market. Your honors, the council humbly submits that the respondents have relied on section 12 in regards to honest concurrent user. So that implies the fact that they accept that there was some use. If it's clearly written that there was no drug in the market on behalf of the appellant, it is also contended that, if your honors may refer to class 5, that pertains to pharmaceutical and veterinary preparations and dietetic food and substance and various other substances and products. It's just not only includes drug under class 5. So the council humbly submits that the use, as the respondents have also agreed via referring to concurrent use, there could have been possibility of other use, although the council is definitely relying upon this argument in arguendo. The council submits, the council pleads extension of time for just 1 minute to wind up. If your honors may be kind enough to grant the same.
Yeah, please.
Much obliged, your honor. And the council is humbly thankful. Your honors, the proceeding with the further point, the council humbly submits that there's huge malified intention on the part of the respondent. How, when they had so many opportunities to contend the same, they had the opportunity to file opposition, post grant opposition, revocation application, but they did not go for anything. Had they been vigilant enough, they could have contended the same. Your Honor, the council humbly submits, although the case might have been stronger on their side, but to claim the same, they have to be vigilant to prove and establish the things, because the law
Counsel,
and judgments
you have
work.
contended this argument already.
Indeed, Your Honor.
Just mention those points which you have you want to rebut actually.
Indeed, Your Honor. Your
Do
Honor,
not
to
repeat the arguments.
much obliged, Your Honors. Your Honors, to proceed further, the council submits, as Your Honors had asked one question regarding the awards, the council humbly submits that it's mentioned in the factual matrix that they had various awards in this field referring to the pharmaceutical products, and that does not imply the fact that they were in Vidya or outside Vidya, Your Honors. And proceeding further, Your Honors, regarding the Verum name, Your Honors, the council humbly submits that while filing the application for registration, they have done due diligence, and while in the due diligence search, there was no trademark appearing in the as the Verum or Verum Guard in the list of the registry, Your Honors. And going by the law, Your Honors, not the facts merely, the council humbly submits and that the section 47 has been misquoted by the respondents. Reason being, the 5 years has not elapsed as of now, because that states, I quote, from date of entry of trademark into the register. And Your Honors, it was entered in the register on 1st January 2018. Thus clearly implied the fact that it's still valid till 1st January 2023 and not 21 as is stated by the respondent. Furthermore, Your Honors, the council humbly states that for prior user, there were certain conditions to be established. First, and they could not take it merely on the basis of duration that since 2015 they've been using. So, with respect to Isha Khosla's judgment, so prior user cannot be claimed only on the basis of this, Your Honors. Secondly, as the council has already stated, the essentials of continuous use and volume of sales have to be established. Thirdly, the well-marked trademark has to be established, and since they mentioned the judgment of NR Dongle versus Whirlpool, rather it clearly states for prior user they have to establish well-known trademark, which in the present case they've not, and the fact sheet are actually silent upon the same aspect, Your Honors. And in regards to Cadilla judgment, the council humbly submits that as the respondent have submitted, there could be likelihood of confusion, and they've relied upon various case laws which are applicable in the general aspect. However, Cadilla clearly states that in regards to pharmaceutical matters, a specific care and caution has to be taken into consideration, because if the Futis Biotech tomorrow comes up with a medicine for the disease of cancer and under the title Verum Guard, and the respondent continues with their use, if the honorable court
we got your point.
Much obliged, Your Honors. The council humbly submits their issues, and it is an honor to plead before the court. And just to wind up, the council states that, as Lord Hewett has rightly said, that justice should not only be done, but should also be seen to be done. And in the times of pandemic, the council has actually knocked the doors of Honorable Supreme Court to claim their exclusive rights upon their registered trademark Verum Guard. It is an honor to plead before the Honorable Supreme Court of Vidya. Much obliged, Your Honors.
Your Lordships, the counsel for respondent seeks permission for rebuttal.
Answer only those questions which has been raised by the council.
Indeed, Your Lordship. Your Lordship, first, they raised a question about finances, that the respondents did not need finances, through which they can conclude that they did not continuously use the product. However, the counsel for the respondent would state that the respondents need the finances right now, because right now they are manufacturing a drug which is to treat a virus. At that time, the respondents were engaged in manufacturing of other drugs, and which is why they did not need finances. However, considering the present situation and the need of the hour, they need finances to increase the manufacturing of the of the drug Viramgard for treating the for Zovid-9. Secondly, the council mentioned that they did get awards, and it is not shown whether they got the awards in Vidya or it was outside. However, the only reason why the councils mentioned about that the respondents have got various awards is to imply that they do have a goodwill and reputation, considering the fact that they were incorporated in 1969. Additionally, your lordships, the council would again make a reference to section 47 and 23b, through which it clearly showed that a 5 years period has elapsed. Also, the Isha Khosla judgment that the council relied on is a high court judgment. The Supreme Court judgments which the respondents stated do not state that the condition of showing volume of sales is required. What is required is given under section 34, and the council for the respondents have satisfied those conditions. These are the points that the council would like to make.
Anything you would like to say on the prior use?
Your lordship, pardon, I could not hear.
Anything you would like to add on to the prior use?
Your lordship, the council would only like to point to the fact that it is clearly mentioned in the fact sheet itself that they have used the mark since 2015 and the customers recognize. So they have shown the condition that they have been using since 2015, and the only condition laid in section 34 is that there should be use by the respondents, and they have proved that. There is no other condition that needs to be proved, and which is why it is clearly shown that they are the prior users, and the rights of the prior users are much greater than the rights of the registered proprietor, and thus we
And
claim that.
why not claiming objections when they filed for the trademark?
Your lordship, at that point of time, the respondents were not aware that they had applied for such a mark. However, there is no bar or obligation on the respondents that they should have objected at that point of time. They are well within their rights to object the trademark even right now, considering section 47 of the act.
Till now, you have not objected.
Indeed, not, your lordship. We did not object till now, since we were not aware of the use of the trademark by them, because they do not have any product in the market. However, now that we have a chance to object it, we are doing so.
Since the petitioner mentioned specifically that when you applied, you have not followed the due diligence. If you had followed the due diligence, you must have got to know that there is a right which they have already registered.
Your lordship, at that point of time, it wasn't the intention of the respondents to get their mark registered, and that is why they did not
So
go
you were
through.
sleeping over your rights.
Indeed, not, your lordship. When we have the chance to oppose them, we are doing so.
You saw all the situations, and the situations demands a lot of profit making. So you plan to register your trademark.
Your lordship, that is a common practice now that we need the registration of mark claim exclusive
Common
right.
practice, you could have used it earlier back there in 2015 itself, if it is a common practice.
Your lordships, the respondents wanted to be sure that the products would work, and once the product started to work, they did file for registration.
The product and the trademark have nothing to do with each other. The product's efficacy is based on clinical trials. A trademark is something which points to the source of the product. How are they correlated that you wanted the products to be worked and to be efficacious and waited for the registration?
Your ladyship, the council will only state that there is a process through which we have to go for filing the trademark, and that we have to that even monetary requirements are there to file the trademark, and which is why we wanted to be sure that if we are getting a mark registered, we do have a product that is working in the market, and then we can register the mark.
But you said that you've been using the mark since 2015. That's your case, isn't it?
Indeed, your ladyship.
Then what were you using the trademark for in relation to which product?
We were using it for various other medicines to treat allergies.
And you thought that that was not to be registered, it was not important to register or to object to the appellant's trademark application. There is a period of opposition. It is published in the journal.
Indeed, your
So when you
ladyship.
applied for your registration, you must have received an examination report where the previous registration must have been mentioned. Even at that point of time, you did not take any action against their registration.
Your ladyship, being the prior users, we did not take action because we have much greater rights, and additionally, why we did not additionally, there is no such thing that the mark needs to be registered and only then we can use the mark. Without a registered mark we can use the mark, and which is why the respondents did not register the mark at that point of time.
That answers why you did not register. But why did you not object to their registration is still not clear to me.
Your ladyship, as mentioned by the council, that because that the respondents were not aware at that point of time, and they plead ignorance for that, that they could not that they did not see that there was a mark being registered. However, as soon as the respondents came to know about it, they did not take any action, because being the prior users, we have much greater rights, and now that the period of 5 years and 3 months has elapsed, we are taking further action of getting their mark off the register.
It means, matlab, you have waked up only when you saw that the petitioner is claiming benefits and he is receiving benefits, some monetary gains. That's why you did, right?
Your lordship, the petitioner is not getting any benefits. They do not have any product in the market. Their business is almost shut regarding the trademark. They are not getting any benefits. So there is no question that we wanted to ride on their goodwill, reputation, or make any illegitimate profits out of it.
But you admittedly, you somehow admit that you, if you have to take your contention in two parts, at one part you are admitting that we were prior users. Okay, accepted that you were prior users, but at the same time you are not accepting that you were sleeping over your rights. Even if you were your prior user, you were sleeping over rights. If you have to take this, if you have to join those two statements, it will come out like this. Even if you were the prior users, you were sleeping over your rights. True?
Your lordship, there is no compulsion on the prior users that they do have to act at that point of time. There is nothing in the act which states that if the prior users come to know about the mark, that it
compulsion is not even now. There is no compulsion now also, no? You are, it is not necessary for you to register now also. Then why are you fighting? Why are you contesting that? Let them do their work. You guys are doing some social service, let it go. Why are you guys contesting then?
Your lordships, now that the customers associate the mark with Viram Guard, if the petitioners start to sell products with the name Viram Guard, it would cause disruption and confusion among the customers, and which is why we want to get the mark registered.
You mentioned they are about to shut. You mentioned that.
No. Indeed, your lordship, we would definitely file for to take their mark off the register, but if that is not
Counsel,
allowed,
you are such a reputed company in business from so long. You have won national awards. You are dealing with the other companies abroad as well. So being aware is one of the important aspect of being in such a situation. You're dealing in this drugs business from so long now. You should understand that this is a very technical aspect which you have missed out.
Apologies for that, your lordship. However, the only point that the council can state is that they acted as soon as possible.
And what if suppose they come up tomorrow with the medicine and then you won't have that 5 years protection under Section 47 as well. So then what would you expect from the court to do?
Your lordship, then the respondents can file a case of passing off against them, since if they have a product in the name of Viramgad now, they would be riding on the reputation.
So you will still sleep over your rights, you will still not file any objection, but if they come up with the product, then you will go for filing of passing over.
Indeed not, your lordship. Now that the 5 years period has elapsed, as mentioned by the council, that the period has elapsed only in July, which was last month, the respondents would now file under Section 47. If your lordships are satisfied, the council would like to say that it was an honor presenting this case before the honorable bench.
From my end.
Your Honor, the council would like to just give certain clarification.
No, not required. We
Your
already
Honor,
gave you ample of time.
The opposite counsel was trying to mislead the court by giving incorrect documents. Your Honor.
And you think that we are sitting here without any reason in our mind that what the opposite counsel is trying to do with us?
No, Your Honor, absolutely.
Or you have taken that court very seriously that the judge is on the trial? Or you have taken the court very seriously that it's the judge who is on the trial? It means we guys are on the trial and everybody is misleading us.
Absolutely not, Your Honor. In fact, it has been a pleasure arguing in front of the bench, and the council does not have any doubt with regarding to the intelligibility of Your Honors. But what the council was just trying to mention that the opposite party was trying to say that they have manufactured a new drug for COVID-19. Although it is not true, in the fact sheet it is given that the same drug which was for malaria was mildly effective, was found to be mildly. No new drug was manufactured. That's it. That is the only fact that the council would like to point. Otherwise, there is absolutely no doubt about Your Honors. The council has huge respect for Your Honor. There's no question about it.
Thank you.
The judges are satisfied with the contentions and the submissions. So shall we move forward?
Yes, sir.
End of this session. Thank you so much, judges, for adjudicating here. Thank you so much, participants. The results will be uploaded very soon. Thank you.
Thank you so much.